Welcome back to Mimi Leaks. Today, we're diving into a class action lawsuit related to a story dominating the headlines. The City of Hollywood Firefighters Pension Fund versus United Health Group, Inc. is a lawsuit that was filed in May 2024. The complaint, amended November 25th, 2024, alleges that United Health Group executives, including slain United Healthcare CEO Brian Thompson, engaged in insider trading, misled investors and the public, and, as a company, participated in overall shady business practices. The lawsuit claims that defendants United Health Group, Inc., United Health CEO Andrew Witty and Executive Chairman Stephen Hemsley, and United Healthcare CEO Brian Thompson schemed to inflate the company's revenues, earnings, and stock price. They did so through company-wide upcoding, by expanding into and manipulating the healthcare industry, and by grossly misrepresenting firewall protections of consumer data. Additionally, the suit alleges that after receiving notice of a non-public DOJ investigation, Hemsley, Witty, and Thompson sold more than $100 million of their own United Health shares at artificially inflated prices, as the market and investors remained unaware of the antitrust investigation. In this episode, we'll break down sections of the amended complaint. Because this is a large class action suit, I thought that starting at the end, or with each count of wrongful conduct, might aid in understanding the relevance of the pages that follow. After that, we'll jump back to the beginning and read the case overview. Then I will provide a summary of the jurisdiction and venue, and last, I will read Section 3, or the parties in the case. While this amended lawsuit is 130 pages, I should say amended complaint is 130 pages, not including exhibits, I plan on making just 2 episodes on this suit. Sections 4 through 10 are roughly 100 pages that expand upon the case as laid out in the overview. So, rather than read these sections verbatim, I'll highlight key components in each section as the second episode. Stay tuned, because understanding this case means uncovering the inner workings of one of the largest healthcare corporations in the world, and how their alleged actions may have impacted millions. And before we start, please subscribe and hit that notification button so that you know when the next episode drops. Now let's get started. In Section 11, Claims, Count 1, violations of 10b of the Exchange Act and SEC Rule 10b-5 promulgated thereunder against all defendants. Plaintiff repeats and realleges each and every allegation above as if fully set forth herein. This count is based upon 10b of the Exchange Act, 15 U.S. Code 78JB, and SEC Rule 10b-5, promulgated thereunder by the SEC. During the class period, defendants violated 10b of the Exchange Act and SEC Rule 10b-5 in that a. Defendants employed devices, schemes, and artifices to defraud. b. Defendants made untrue statements of material facts or omitted to state material facts necessary in order to make the statements made, in light of the circumstances under which they were made, not misleading. C. Defendants engaged in acts, practices, and a course of business that operated as a fraud or deceit upon plaintiff and in the class in connection with their purchase of United Health common stock during the class period. In furtherance of their scheme and wrongful course of business, defendants, and each of them, took the actions set forth herein. During the class period, defendants United Health, Witty, Hemsley, and Thompson engaged in a scheme and wrongful course of business and disseminated or approved the statements specified above, which they knew were false and misleading in that they contained misrepresentations and or failed to disclose material facts necessary to make the statements made, in light of the circumstances under which they were made, not misleading. Defendants' misconduct was intended to, and did, deceive the investing public, including plaintiff and other class members as alleged herein, artificially inflate and maintain the market price of United Health securities, and cause plaintiff and other members of the class to purchase or otherwise acquire United Health common stock at artificially inflated prices. As a direct and proximate result of the defendant's wrongful conduct, plaintiff and other members of the class suffered damages in connection with their respective purchases of the company's common stock during the class period in that, in reliance on the integrity of the market, they paid artificially inflated prices for United Health common stock. Plaintiff and the class would not have purchased United Health stock at the prices they paid, or at all, if they had been aware that the market prices had been artificially and falsely inflated by defendants' misleading statements. Upon disclosure that the company had been disseminating false and misleading statements to the investing public, the plaintiff and other members of the class suffered financial harm. Count 2. Violations of 20A of the Exchange Act against all defendants. Plaintiff repeats and realleges each and every allegation above, as if fully set forth herein. During the class period, defendants participated in and oversaw the operation and management of United Health and conducted and participated, directly and indirectly, in the conduct of United Health's business affairs. The individual defendants were able to, and did, control the contents of various reports, press releases, codes of conduct, and public filings, which United Health disseminated in the marketplace during the class period concerning its business and results of operations. Because of their senior positions, they knew the adverse, non-public information about United Health's business as alleged herein. As officers and/or directors of a publicly owned company, the individual defendants had a duty to disseminate accurate and truthful information with respect to United Health's financial condition and results of operations, and to correct promptly any public statements issued by United Health which had been or had become materially false or misleading. Each of the individual defendants acted as a controlling person of United Health. By reason of their senior management positions and/or being a director of United Health, each of the individual defendants had the power to direct the actions of and exercise the same to cause United Health to engage in unlawful acts and conduct complained of herein. Each of the defendants exercised control over United Health's general operations and possessed the power to control the specific activities which comprise the primary violations about which the plaintiff and other members of the class complain. Throughout the class period, the individual defendants exercised their power and authority to cause United Health to engage in the wrongful acts complained of herein. Defendants therefore were controlling persons of United Health within the meaning of 20A of the Exchange Act. United Health had the power to control and influence company officers and other executives, including defendants Witty and Thompson, through its power to hire, fire, supervise, and otherwise control the actions of its employees and their salaries, bonuses, incentive compensation, and other employment considerations. By virtue of the foregoing, United Health had the power to influence and control, and did influence and control, directly or indirectly, the decision-making of defendants Witty and Thompson, including the content of their public statements. United Health, therefore, was a controlling person of defendants Witty and Thompson within the meaning of 20A of the Exchange Act. By reason of the above conduct, defendants are liable pursuant to 20A of the Exchange Act. Count 3. For violations of 20A of the Exchange Act against Hemsley and Witty. Count 3 is brought pursuant to 20A of the Exchange Act against Hemsley and Witty on behalf of plaintiffs and members of the class who were damaged by Hemsley's and Witty's insider trading. Plaintiff repeats and realleges every allegation above as if fully set forth herein. As detailed above, Hemsley possessed material, non-public information when he sold his stock, and he took advantage of his possession of material, non-public information regarding United Health to obtain over $211 million of insider trading proceeds during the class period. Plaintiff made the following purchases contemporaneously with Hemsley and Witty's sales. And here we have a list of the defendants, which ones were the sellers, the date of the sales, the number of shares sold, and the sale price of the defendant sales while in possession of material non-public information versus the contemporaneous purchases by CalPERS, which is the California Public Employees Retirement System, their dates of purchase, number of shares purchased, and purchase price. As United Health's top executives, Hemsley and Witty each owed a duty to United Health and its shareholders to maintain the material, non-public information in confidence and not trade on the basis of it. By reason of the above conduct, Hemsley and Witty are liable pursuant to 20A of the Exchange Act. Prayer for relief. Wherefore, plaintiff demands judgment against defendants as follows. A. Determining that this action is a proper class action and certify plaintiff as a class representative under Rule 23 of the Federal Rules of Civil Procedure and appoint Robbins, Geller, Rudman, and Dowd LLP as class counsel. B. Awarding compensatory damages in favor of plaintiff and other members of the class against all defendants, jointly and severally, for all damages sustained as a result of defendant's wrongdoing, in an amount to be proven at trial, including interest thereon. C. Awarding plaintiff and the class their reasonable costs and expenses incurred in this action, including reasonable attorney's fees, accountant's fees, and expert's fees, and other costs and disbursements. And D. Awarding such equitable relief, including disgorgement and or injunctive relief, that this court may deem just and proper. Demand for jury trial. Plaintiff hereby demands a trial by jury. And this is dated November 25th, 2024, and this being the supplemental or amended full complaint. Back to the overview. Lead plaintiff, California Public Employees Retirement System, plaintiff or CalPERS, individually and on behalf of all others as similarly situated, by plaintiff's undersigned attorneys for plaintiff's complaint against defendant's name herein, alleges the following based upon personal knowledge as to plaintiff and plaintiff's own acts, and information and belief as to all other matters. Plaintiff's allegations are based upon, among other things, the investigation conducted by and through plaintiff's attorneys, which included, among other things, a review of defendants' public documents, conference calls, and announcements made by defendants, U.S. SEC filings, releases published by and regarding United Healthcare Group, Inc., analyst reports and advisories about United Health Group, Inc., media, statements by percipient witnesses, and other publicly available information. Plaintiff believes that substantial additional evidentiary support will exist for the allegations set forth herein after a reasonable opportunity for discovery. 1. Overview of the action. This securities fraud class action is brought on behalf of purchasers of United Health Group, Inc., common stock between September 22, 2021 and February 27, 2024 inclusive, the class period, seeking to pursue remedies under 10B, 20A, and 20A of the SEC Act of 1934, the Exchange Act, and SEC Rule 10B-5 promulgated thereafter, against United Health, two of the company's senior executives, Andrew Witty, the CEO of United Health, and Brian Thompson, CEO of United Health subsidiary United Healthcare, and the chair of the company's board of directors, Stephen Hemsley, collectively herein referred to as the defendants. United Health is a health insurance company that provides insurance to individuals, employers, and small businesses. Today, its insurance arm, United Healthcare, is the largest insurance provider of the United States. In 2010, the ACA was enacted into law. The ACA introduced medical loss ratios, or MLR, requirements that required insurance, also called payers, to spend a greater percentage of premiums collected from patients on actual health care, rather than administrative costs or insurer profits. The ACA placed downward pressure on UnitedHealth's profits, and the company immediately ramped up its vertical expansion. In other words, expanding into areas outside of health insurance to diversify its revenue streams and maintain its growth. In April 2011, UnitedHealth launched its new subsidiary, Optum. Optum does not provide insurance, but rather provides healthcare services and products through 3 businesses: Optum Health for healthcare providers, Optum RX for prescriptions, and Optum Insight for healthcare technology products. After launching the new brand, UnitedHealth focused on expanding its non-insurance business in order to widen its influence in the healthcare industry. Owning both a healthcare insurer and medical providers positioned UnitedHealth to circumvent the ACA's MLR restrictions. UnitedHealthcare could collect premiums, send payments to Optum Health for treatment, and pay itself through Optum for the requisite level of healthcare treatment to satisfy the MLR requirements. Doing so allowed UnitedHealth to then retain profits on both sides of the ledger. From the enactment of the ACA to the start of the class period, UnitedHealth spent over $60 billion expanding into the far corners of the healthcare industry and accordingly establishing immense market power it could use to manipulate other participants in the industry. This case arises out of the defendant's abuse of power. Defendants engaged in a scheme and wrongful course of business which was designed to, and did, artificially inflate the company's revenues, earnings, and stock price. As part of the scheme and wrongful course of business complaint of herein, defendants formulated, implemented, and oversaw an illegal company-wide upcoding gambit. Defendants also misrepresented the breadth, scope, and integrity of Optum's existing firewall protections while concurrently concealing Optum's ability to circumvent those very firewall protections. Finally, defendants used UnitedHealth's monopolistic dominance to engage in its anti-competitive practices to consolidate its control over healthcare services and eliminate competition. Defendants employed several different mechanisms to effectuate their wrongful course of business. For example, UnitedHealth induced providers to find new diagnoses by paying bonuses to providers who upcoded. UnitedHealth trained providers to use buddy codes, that is, adding new diagnoses based upon existing ones. UnitedHealth also purposefully leveraged its house calls program, whereby the company would dispatch nurse practitioners to members' homes to perform physical assessments. Defendants also exploited the house calls program by using tools designed to find diagnoses that did not exist, including software specifically programmed to recommend lucrative diagnoses and unreliable medical devices. Defendants used such tools even though they were aware the tools were prone to issue false positives for lucrative conditions. Doctors and nurses who worked for UnitedHealth during the class period have admitted that they added codes they did not truly believe existed because UnitedHealth pressured them to do so. Defendants' upcoding scheme worked as planned. According to the analysis of Medicare data by Wall Street Journal, the WSJ, in 2021 alone, UnitedHealth received $8.7 billion in taxpayer money for diagnosis codes that no doctor treated. The cost of defendant's scheme was not solely financial. It also had a real-life impact on America's senior citizens. Doctors around the country have prescribed panic calls from UnitedHealth members who noticed alarming new diseases listed on their medical chart that their doctor never mentioned. Former UnitedHealth physician, Dr. Susan Baumgartel, admitted that when she got those house calls, she always tried to tell patients the truth, as uncomfortable as it was. And that, she said, "I don't really think you have that condition, but I'm supposed to code it as you having it so that I get paid more." Through the class period, Defendants frequently spoke to investors about the company's Medicare Advantage business and the house calls program while concealing the upcoding scheme. For example, on September 22, 2021, the first day of the class period, UnitedHealth responded to questions about its coding practices by ensuring investors the following. UnitedHealth's in-home clinical care programs provide significant benefits to seniors and for years have been a valuable offering to ensure our members continue to receive cost-effective, appropriate care. Defendants continued to use similar false and misleading assurances throughout the class period. Optum acquires Change Healthcare and misleads investors about data firewalls. On January 6, 2021, UnitedHealth announced its largest acquisition ever. Optum Insight would acquire Change Healthcare, or Change, a healthcare technology company, for $13 billion. Change operated a clearinghouse that acted as the pipes of the healthcare industry, processing health insurance claims and moving data from entity to entity. According to a UnitedHealth estimate, more than half of American medical insurance claims pass through or touch Change's systems. Internally, UnitedHealth's then CEO, David Wickman, lauded the acquisition because it granted UnitedHealth access to the Change data, calling that access the foundation of the deal. Indeed, the Change acquisition gave UnitedHealth access to critical competitor information, including pricing structures, claims data, and billing practices. Industry groups, however, responded differently, immediately questioning the propriety of the deal, citing serious antitrust concerns. On February 24, 2022, the DOJ sued to block Change acquisition on antitrust grounds, arguing UnitedHealth would gain access to sensitive data that it could then wield against its competitors. UnitedHealth immediately refuted the DOJ's allegations and assured investors that Optum possessed the best in-class firewalls and compliance programs that maintain the integrity of their customers' data and information. Throughout the class period, defendants repeatedly made similar assurances, insisting that UnitedHealth had internal firewalls that prevented the share of competitively sensitive information across business units. Ultimately, UnitedHealth's assurances won the day. The U.S. District Court for the District of Columbia decided in Optum's favor, expressly crediting UnitedHealth's purported history of maintaining data firewalls. The firewalls UnitedHealth described to the court and the public were illusory. They simply did not exist. In truth, Optum's business applications shared data with other Optum business applications. And what they did not do is prohibit Optum from using external customer data to benefit those Optum businesses competing with external customers. The lack of firewalls and lack of security also ultimately led to the largest security breach in the history of the United States healthcare system, which hackers achieved simply by acquiring a working username and password. UnitedHealth receives notice of a non-public DOJ investigation, and UnitedHealth executives respond by selling more than $100 million of their own UnitedHealth shares. On October 10, 2023, UnitedHealth received notice that the DOJ had launched a non-public antitrust investigation into the company. Concealing this material information from investors and public, UnitedHealth Chairman Stephen Hemsley and several other senior executives immediately took action, selling more than $100 million of their own UnitedHealth stock at artificially inflated prices as the market and other investors remained unaware of the new federal antitrust investigation. The relevant truth leaks out. On February 27, 2024, the Wall Street Journal reported that the DOJ was conducting an antitrust investigation into UnitedHealth. According to the WSJ, the DOJ's investigation centered around, among other things, quote, Medicare billing issues, including the company's practices around documenting patient illnesses, as well as issues related to other anti-competitive practices at Optum and UnitedHealthcare. News of the DOJ investigation was severely troubling to investors. with industry analysts subsequently expressing concern that the DOJ investigation would expose United Health's Medicare Advantage risk coding practices that make your Medicare Advantage beneficiaries look sicker than they really are in order to make more money, that United Health's firewall has a lot of holes in it, and that ownership of physician and health plans and health plan units affect competition. In response to those revelations, the price of United Health stock declined over $27 per share, falling from $525.32 per share on February 26, 2024 to $498.28 on February 28, 2024. U.S. lawmakers take notice and demand further action. United Health's anti-competitive practices have garnered intense government scrutiny, including congressional hearings. In a rare case of bipartisanship, lawmakers from both sides of the aisle demanded intervention. For example, Senator Elizabeth Warren, Democrat of Massachusetts, stated the following: "Because United Health has bought up every link in the healthcare chain, it's in a position to jack up prices, squeeze competitors, hide revenues, and pressure doctors to put profits ahead of patients. United Health is a monopoly on steroids." While Republican Representative Buddy Carter, a Republican of Georgia, bluntly stated that United Health needs to be busted up. Based on the highly suspicious stock sales by Hemsley and others, Senator Warren and 16 other lawmakers sent a letter to the SEC urging them to open an insider trading investigation. The lawmakers stated that these trades had revealed a disturbing fact pattern, particularly since they came during a DOJ investigation, when such trades should have been prohibited. An Office of Inspector General report and whistleblower media reports confirmed the fraudulent upcoding scheme. In July, August, and October 2024, United Health's fraudulent upcoding scheme was confirmed in a series of bombshell investigative reports published by the Wall Street Journal and Stat News. Over the course of 6 investigative reports, fortified by numerous whistleblower accounts from former United Health employees, journalists detailed how defendants exploited the house calls visits and pressured doctors and nurse practitioners to manipulate diagnosis codes, securing for themselves billions of dollars of inflated and unsupported payments. On October 24, 2024, the OIG released a new report titled "Medicare Advantage: Questionable Use of Health Risk Assessment Continues to Drive Up Payments to Plans by Billions." The government watchdog found that United Health reaped $3.2 billion in extra federal payments in 2023 for diagnoses from in-home health risk assessments, HRAs, and HRA-linked chart reviews. According to the report, United Health accepted these payments even though the patients did not receive any additional treatment or medical services following the new diagnoses. One top MA company, United Health Group Inc., stood out from its peers, especially for its use of in-home HRA and HRA-linked chart reviews to generate risk-adjusted payments, the OIG report noted. Throughout the class period, United Health leveraged its monopolistic power to crush competition, manipulate government officials, and force others in the healthcare industry to cede to its demands. In the process, United Health unlawfully obtained billions of dollars of revenue from the federal government, healthcare providers, and its own members. When investors learned the truth, the inflation in the price of United Health's stock dissipated. Two, jurisdiction and venue. To summarize, this section sets forth the arguments as to the claims asserted, the court's jurisdiction and venue, based on the codes listed in this section. Many of the acts charged in this complaint occurred in substantial part in this district, and the company's principal executive offices are located in this district as well. Defendants use interstate commerce, including the mail, interstate telephone communications, and national security exchange facilities in connection with the acts, transactions, and conduct alleged in the complaint. Three, the parties. A, plaintiff. Lead plaintiff California Public Employees Retirement System is the largest state public pension fund in the United States, with more than 2 million members and more than $500 billion in assets under management. CalPERS purchased United Health common stock during the class period, as set forth in the certification attached hereto as Exhibit 7, and was damaged thereby. B, defendants. Defendant United Health Group, Inc. is a publicly traded healthcare company incorporated in Delaware and headquartered in Minnetonka, Minnesota. United Health owns an insurance business, United Healthcare, as well as a medical services provider and technology business, Optum. United Health is one of the largest corporations in the world. Their 2023 revenue was $371.6 billion. During the class period, United Health traded on the New York Stock Exchange under the ticker UNH. Defendant Andrew Witty has been CEO of United Health and on United Health's Board of Directors, the board, since February 3, 2021. Until his appointment as CEO and director, Witty was the Executive Vice President of United Health and CEO of Optum from March 2018. Prior to his appointment as Optum CEO in March 2018, Witty served as independent director on the United Health board. In these roles, Witty oversaw United Health and Optum's operations. During the class period, Witty spoke often about the House Calls program, calling it a true collaboration between Optum and United Healthcare, and also spoke on United Health's commitment to maintaining a data firewall between Optum and United Healthcare. He signed each of the company's Forms 10Q and Forms 10K during his time as CEO. Defendant Stephen Hemsley has been the chair of United Health's board of directors since September 1, 2017. He has been a director since 2000. Hemsley also served as CEO of the company from September 2017 through November 2019. In 21 and 22, Hemsley sat on the board's Health and Clinical Practice Policies Committee, which is responsible for oversight of management's initiatives to improve healthcare affordability. During the class period, Hemsley sold more than 21% of his United Health shares for the proceeds of over $200 million. Defendant Brian Thompson has been the CEO of United Healthcare, United Health's insurance business, since April 7, 2021. Thompson has held numerous leadership positions at the company since he started work in April 2004, with a primary focus on the financial side of the Medicare business. From July 2019 to April 2021, Thompson was CEO of United Healthcare government programs. In this role, he oversaw the United Healthcare Medicare and Retirement Division, a business arm focused on the company's coverage of Medicare members. From April 2017 to July 2019, he was CEO of United Healthcare Medicare and Retirement. Prior to that, from December 2012 until April 2017, Thompson was the CFO of United Healthcare Medicare and Retirement. During the class period, Thompson spoke to investors regarding the House Calls program and sold over 31% of his United Health shares for proceeds of over $15 million. Defendants Witty, Hemsley, and Thompson are hereinafter referred to as individual defendants. The individual defendants made, or caused to be made, false or misleading statements that caused the price of United Health common stock to be artificially inflated or maintained artificial inflation in United Health's common stock during the class period. Each of the individual defendants was directly involved in the management of day-to-day operations of the company and was privy to confidential, proprietary information concerning the company and its businesses, operations, services, competition, and present and future business prospects. That wraps up today's episode of Mimi Leaks, and next time we'll cover the remaining sections, and if you're still here, thanks for sticking around, and please don't forget to like and subscribe. We'll see you next time, and stay safe.